Welcome to the Secure Futures Workshop video series, brought to you by the Gateway Down Syndrome Association. Today we welcome attorney Paul Gantner from Amen, Gantner and Capriano, estate planning and elder law attorneys. This video will provide information regarding powers of attorney, guardianship, and estate planning for families caring for a loved one with Down syndrome.
All things legal here and securing futures. Thanks for being here. I know it's a lot. We're always trying to learn as much as we can, and knowledge is power. And one of the main reasons that some of the things we talk about, they're like, well, why doesn't everybody do this? A lot of times it's because people just don't know. And you don't know what you don't know. And just getting that first step towards getting the best case scenario is why we do this as a routine. I always want to add as many education items as we can, both as a law firm and through partners like Gateway Down Syndrome Association. And it's such a great group. So just a little background about who I am. So I'm licensed in Missouri and Illinois. So unfortunately, that's kind of the limitation of what I know. I'm thinking that's probably going to cover the Gateway area. So hopefully that's good. I went to SLU for undergrad. I went to Mizzou for law school and my MBA. I've been board members of, estate planning, American Academy of Estate Planning Attorneys nationwide, the Missouri chapter of National Academy of Elder Law Attorneys. I was in the 2022 St. Louis Business Journal for 40 Under 40 back when I qualified for such an award. But this is the area of law that I really focus on. And if one thing I can pass along is it's really hard to be a general practitioner and know much about anything. So we really try to focus on, and whether it's us or anybody else that you would use, just make sure it's an attorney that really focuses their practice on things we're going to talk about. Again, it's myself. My firm is Amen, Gantner, and Capriano. If you're in the St. Louis area, we're at basically 270 and 44 in Sunset Hills. If you listen to KMOX, you may hear our names from time to time. But that's Charlie Amen in the middle, myself, and Jackie Capriano is my partner on the left there. And I'll talk about at the end. I'm going to focus a lot on education. Like I said, spitting as much stuff out at you as I can in this time period. And then I will tell you a little bit about what our process is, so that if somebody does say, hey, I'd like to follow up and work on this with you guys, or what would it look like, I'll tell you what that is. And in the first meeting in our process is always with my partner, Jackie, because she's just a master at that plan design stuff. So here's our goals. Understand the options available, create a plan for yourself, avoid the mistakes, and not the least of which is just being unprepared. A lot of us think of this stuff as something that we got to do. We know it's on the list of things to do, but then next year it's still on the list of things to do. And next year it's still on the list of things to do. And in these cases that we're talking about, not only do we run the risk, of course, of it being too late, we certainly run the risk of missing out on benefits that may have been available a year ago that could have put you in a lot better position. So hopefully, if nothing else, you get a little bit more information so that you can take that step forward. Let's see if I can minimize. Awesome. So I'm going to talk about government benefits. And again, there's no way I can tell everybody exactly all the things you have to do and can do to apply for all the various benefits. What I want to try to do is let you know the different terms that you may have heard along the way, some of the steps that you should take, first steps towards doing that. Some of might this be something I qualify now or may in the future, and understanding the difference, because it's really easy to mix up Medicare and Medicaid. And you get an award letter from Social Security Administration, and I ask, oh, is it SSI? Is it SSDI? And people are like, I don't know. I think it's SSA, because it's really hard to tell the difference. And unfortunately, all of those benefits have different requirements, different financial requirements, different age requirements. And so it really does matter what benefits you're receiving and how to kind of read those letters. And again, unfortunately, I can't go too in depth about it, but I at least want to highlight some of the things you should be looking for. The other thing I want to talk about is guardianships, or in Missouri, we call guardians, and then conservators for any of the money involved. In Illinois, they call it guardian of the person or guardian of the estate. A lot of times, people talk about guardianships like it's just something you can go pick up at the grocery store and do, and it's unfortunately not that. And also, it may or may not be necessary or appropriate in your situation. And so I'll talk about what that is and what steps are to pursue that, or what other alternatives may be involved or available. And then we'll talk about other planning options. So when there's money involved, which is a lot of what, of course, you need an attorney for, is how to protect the money, how to make them maybe countable money, not countable money. How do we make something that would otherwise have a payback provision, not have a payback provision? You may have heard ABLE accounts or special needs trusts, and what does that mean, and how are they different? And I'm going to introduce those things to you, try to give you a high level explanation. And then hopefully, again, whether it's with us or anybody else, you can follow up on what may be appropriate for you and your family. And then, of course, plenty of time for Q&A. Again, I would recommend throwing it in the chat box. Logan and McKinney can probably tell, like, is this an appropriate time to just ask the question while we've got it? Or should we just wait till the end and kind of run through all those things? And that's cool too. So what if we do nothing, right? It's 100% easier to do nothing than it is to do anything. And so unfortunately, the default is doing nothing. And the problem with doing nothing is, what happens if the worst case scenario happened to you? You are the lifeblood of this loved one in your family, and something happens to you. And you haven't done the planning necessary to have a succession, or to have the benefits available, or to protect your money from becoming their money and therefore kicking them off benefits. And we want to make sure that doesn't happen, because the worst case scenario is we don't have an advocate, we don't have benefits that we should be having benefits, and therefore we don't have the peace of mind, we don't have the joyful life, the opportunities that could be there if you just plan ahead. Because most of the time when I speak to clients about any type of planning, it's not about like, if I spend this much, how much money can I get? Let's do a cost benefit analysis. The cost benefit analysis is, you either have a very high quality of life, happiness, comfort, peace of mind, or you don't, because things haven't been done and you haven't exhausted the options of what's available. But always, like I said, the first step in our roadmap after the education is always going to be a specific personal plan design. What are your goals? What are your concerns? What are you trying to avoid? And what tools do you need? What planning do you need to do to get there? So let's, again, start hitting the ground running with some government benefits that are available. So there's a difference between means tested programs and entitlement programs, and that's really important. So somebody says they're on Social Security disability, or they're on disability benefits through Social Security, or they have Medicaid, or they have Medicare, which again, I wish I could say I can trust the words that are coming out of everybody's mouth, but a lot of times there's just confusion about what benefits people are actually on. But SSDI, basically, you can have as much money or as much income as you want, and it won't kick you off because you qualify for SSDI. So SSDI, typically you either have to have enough work quarters on your own to qualify for that benefit, that if you should become disabled, and generally it's 40 work quarters, but if you're younger, they have a formula for figuring out how many work quarters you can get. Or alternatively, you can have disabled adult child SSDI, where you qualify under, where the disabled adult child qualifies under their parent's work record. And generally, their parent would either have to be deceased and they're getting some sort of survivor's benefit, or their parent would have to be retired or on disability under their own work record to get that. And then Medicare is the same sort of thing. If you're on SSDI or SSI, eventually you could, after 24 months, have Medicare, which is kind of the health insurance that helps with that. Whereas the other side of things, where we do have limitations on how much income and how much assets we can have, you're typically looking at supplemental security, SSI. You're looking at Medicaid, which, by the way, when we say Medicaid in Missouri, MoHealthNet, there are dozens of different kinds of Medicaid. So a lot of times when people say, my loved one receives Medicaid, okay, what kind of Medicaid? And I don't know what you mean. Medicaid from Missouri. What type? They all have different rules and everything else. So one thing I would encourage you always to do is have a master folder of every government benefit, um, entitlement or means tested program, any award letter that you've gotten, any annual recertification or update, because the first thing anybody's going to ask for if they're trying to see if you're maximizing what you could be getting is, what are you on now? And then let's see what your situation is. And is there stuff that you're not getting that you should be, or a higher amount of something you're already getting, but you haven't filled something out right, or you haven't moved something from bucket A to bucket B? Um, and so these are all it really starts with making sure you're really clear. I just had an appointment. Another law firm, one of the bigger estate planning law firms in town, doesn't do any special needs planning, elder law planning, anything like that, government benefit stuff. So anytime they have a client or a client with a loved one who's on government benefits, they refer to us. And I said, okay, the lawyer called me first and said, hey, we're doing a estate plan for mom, and son is on SSA benefits, and we're trying to figure out how to best protect things. And I said, okay, well, what specific benefits? He goes, I don't know what that question means. I'll ask her. And of course, mom's like, I don't know. It says SSA benefits. I don't, because that's what it says at the top. But then there's little reference codes on the top right that might say DI, comma, A. It might refer in this very confusing letter to potential for supplemental security insurance, but you aren't getting it. Um, Keep those award letters, because you need somebody who knows what they're looking at to be able to look at and read exactly what you're looking at, whenever you're doing any sort of benefits. Um, SSDI, as I said, you could have on your own work record, even if you're 45 and you've been working your whole life, and then something happens where you no longer can obtain substantial gainful employment. You could have SSDI under your own work record, and what the benefit is depends on what your income was during that time, what you paid into it. But it's possible you can also get disabled adult child benefits. And if you have a disabled adult, and when you're considering when you retire, and you're looking at, should I do 62? Should I do 65, 67, 70? Sometimes that what benefits may be available to your child and what limitations may be lifted is something to incorporate in that question. If you have maybe dad of disabled adult child passed away and you haven't pursued that at all, and there might be survivor's benefits, or mom passed away, please look into that. And then again, with insurance, usually when we have SSDI, we're going to have Medicaid for at least the first 24 months. Sometimes there's some sort of COBRA or parents insurance that can keep going until they qualify for Medicare, which would be 24 months later. Sometimes even once we qualify for Medicare, we're going to supplement that with some Medicaid. And while the Medicare may not have income and asset limitations, the Medicaid would. And even if it's just waiving the $202 a month that Medicare would cost if you didn't qualify from an asset and income standpoint, it may be worth doing some planning so you can save yourself that $202 a month that you would be paying for Medicare Part B, and then whatever, prescriptions or supplements would be available. Um, Again, usually when we're doing asset protection planning, um, it's because if you died and you left a CD to your loved one for $20,000, you would be creating such a firestorm of problems because that $20,000 may be enough to kick them off their income that they were receiving every month, their health insurance that they were getting, maybe their subsidized housing that they were getting. And what should we do about that? Does it mean don't help them? Don't provide any benefit or support? Of course not. It just means do it better, do it smart, use the tools that you can to make sure that it is not a countable asset and they can continue to get that SSI benefit, Medicaid, or in-home services. And again, I'm going to talk a little bit about the tools that we're going to use more than what the benefits are, but I just want to lay out generally these are the key terms that you should be looking for and what the difference is. Guardianships. Most of the time when we get a referral from a community advocacy group, Down Syndrome Association, ARC, Easter Seals, whatever, it's usually, I was told I should go get a guardianship. The doctor said I should go get a guardianship. The bank said I should go get a guardianship. And here we are. And maybe it's my adult child who's 30, I've never had problems making decisions for. And all of a sudden somebody says I can't make decisions for my child because they're over 18 and it's their decision. What do we do? And so that's when we get into the field of, is a guardianship appropriate? Now, as I mentioned before, a conservatorship is what we call the person in charge of that person's assets. Literally, the conservator would hold title to the assets. They would be the signer on the account. It would be for somebody who can't manage their own financial resources, and somebody else should be appointed. That's the conservator. The guardian is the person who would be making decisions for that person. Now, until your child is 18 years old, the legal parent is always the guardian of that person. But at 18 years old, regardless of diagnosis, prognosis, what the doctors say, that person is presumed to have capacity to make their own decisions. And therefore, you as parent have zero authority over what they sign or don't sign. There is no authority for anybody to sign for an adult on their behalf. A legal spouse has no authority. An adult child has no authority unless they are appointed in a position that gives them authority. Now, a guardian and conservator is one way to get that legal authority. What's the problem with that? One is, as I talked about, people will often talk about a guardian and conservatorship as something you can just go online and click a button and get, or go to the grocery store and pick up like you're picking a dozen eggs. You're picking up a dozen eggs, you're going to grab a guardianship while you're there. That's not what a guardianship is. What a guardianship and conservatorship is you're literally suing a person, you're filing a petition to say, this person lacks the ability to make their own decisions, and I should be making them for them. So a court takes that very seriously. They say, okay, if you believe that, before we take decision-making authority and ability to manage your own finances away from a legal adult, I need to A, make sure that person lacks the capacity to make their own decisions, and B, make sure you're the right person to make those decisions. And that requires a court process. So when you file the petition to say this person cannot make their own decisions and I should be making them for them, one of the things you'll have to do is file doctor's interrogatories. So that's a doctor is laying out this is the medical situation. Here's why they lack the ability to handle it themselves, and here's why they lack the ability to manage their finances. And yes, we do think it is appropriate. We file that with the court. The court will then appoint something called a guardian ad litem. And a guardian ad litem is a court-appointed attorney that then represents the person that's being told they can't manage their own assets and resources. Again, this is your kid or your loved one that you've been taking care of since they were 2. All of a sudden now they need somebody else to represent them instead of me. What's going on? Yeah, they need to make sure that they're protected and no one is taking advantage of somebody. So they need to get their own kind of eyes and ears on the person and ask themselves and ask questions to find out, is a guardianship and conservatorship appropriate? A, and if so, is this person a good person, or might there be somebody else that is appropriate? So usually your attorney and that guardian ad litem would then have a conversation prior to any hearing, get an idea of where things lay out, and then we'd set a date for a hearing, talk to the judge, kind of tell the judge, here's what's going on, and then we would have to hold the hearing. You would usually have to, you as the petitioner would have to be on the stand, and your attorney would go through all the different who you are to this person, why do they need help, and why are you the right person? And then the guardian ad litem may decide that their client should be on the stand to defend against the guardianship or defend against you being the person nominated. Or they might waive that right, and maybe the court will say, I've heard enough, makes sense, and we'll appoint this person as legal guardian and conservator. So we got a court hearing and we got two lawyers involved at least. And then we go with what happens after that order is issued. After that order is issued, if there's no money involved, or if the only money is Social Security, we can usually have you appointed as the Social Security rep payee as well, and not have to have an ongoing conservatorship. If, however, they determine that they also have money of their own and can't manage that, maybe they have a job that they earn just a little bit of money on their own, or they inherited money and that's already in their name, well, then we need a conservator. With the guardianship, you'll just have to file an annual report to the court to say, here's the living situation, here's what we're doing, here's, why it's still appropriate, why you're still the appropriate person. If they ever move from this facility to that facility or from your house to a group home or anything like that, you certainly need to update the court, but otherwise it's an annual report. The conservatorship is generally restricted, which means if you want to buy new socks and underwear using that money, the court has to approve it. If you want to use money that they have for a summer camp or a flight, the court has to approve it. So I say all this to say that a guardianship and conservatorship it's not that it's never appropriate. It certainly is. It's just that we usually want to use that as a last resort and see if there are less restrictive ways that we can accomplish the same way, the same results. Now, who will serve as the guardian conservator? I assume everybody here is here because they are the loving, caring family member that would serve in that role. Unfortunately, there are people that don't have someone, and that's when the public administrator or the state becomes the guardian and conservator. And that's when you have to ask the state specifically for, can I do this? Can I do that? I want my loved one to live here. And I've had clients that say, I really don't like where they have my nephew, but the public administrator is the guardian. I'm just the aunt or the uncle, and I want to tell them to move, but they said they can't listen to me, that I don't have any authority. Can I do anything? And the answer is really no. You can tell, obviously observe and report and tell the guardian, but unless you are the guardian conservator, it's not your choice, it's their choice. So all you can do is kind of make recommendations and go from there. So again, what do you want to consider when pursuing a guardianship or not? Is do they have capacity, if not to do everything themselves in terms of writing checks and buying a house and a car or whatever? Maybe some help could be helpful, but maybe we don't need to remove their rights to make decisions. We just need somebody to kind of help. Do we want the court to supervise it, or do we want it to be outside of the court? And do we want a little bit more flexibility on the things that are used? One alternative to that, before I get to the kind of other assets that we use a lot of times, is powers of attorney and healthcare powers of attorney. So Missouri is one of 4 states that there is no default healthcare surrogate law. What does that mean? It means the second a person turns 18, there is no one on earth who has the authority to make healthcare decisions for that person, even when they lack the ability to make their own healthcare decisions. The only way you could get that is by them delegating it on a healthcare power of attorney or seeking a legal guardianship and conservatorship. So when do we choose the power of attorney route? Usually, if we have a person who has the ability to understand if I can't make my decisions, I trust mom to make those decisions, or I trust my grandma to make those decisions, or I trust my uncle to make those decisions, or my brother. And therefore, I understand that means that they can talk to the nurses and doctors instead for me. That's that's good enough. We can sign the healthcare power of attorney, the property power of attorney. I trust this person to pay my bills and to deal with my money if I can't do it. And I understand I could choose this person, that person, or this person, but that person's the one that I want. Maybe that's enough capacity to understand to sign a power of attorney. Now, the one downside to the power of attorney is it doesn't take any rights away from the person that signed the power of attorney. So one time we definitely want to seek a guardianship and conservatorship is if even if we can appoint a helper, this person might get taken advantage of and spend their money on something they shouldn't spend it on, or make a reckless decision when it comes to money or assets or health or any of those things. The only way to make sure that we can protect that is to remove their right to make those decisions, and that would be a legal guardianship and conservatorship. Um, so so that's kind of big picture there. I know a couple things came up on chat, but are we good to go forward, or is now a good time to talk about that stuff? Anybody?
I think we, I think you can answer this one. If you have guardianship already, does that cover the need for a conservator?
No. So if you have a guardianship, and again, I'm going to assume Missouri because that's the reason we use guardianship and conservatorship. If you're in Illinois, if you have a guardianship of the person, does that cover a guardianship of the estate is kind of the same question. And the answer is no. So let's say the person didn't have money when they were 18, but now they have money. And I want to be the person that's kind of in charge of that. You would have to petition to add a conservator to the guardian. Now, sometimes the court will say, well, that person was right for the guardian, therefore the right for the conservator. But that's not always the case. Maybe the person that's right for the guardian is excellent at medical decisions, but is terrible with money and doesn't have good credit and has no, has no, they do run credit checks. Usually they exempt that for like parents and a couple of other close relatives, but they still want to do a little bit of vetting, and you're still going to need a separate form. If you went to their bank account and said, I'm the guardian, I need to spend money out of this account, they'd say, congratulations, but the legal guardian doesn't give you authority to access this account. You would need to be conservator. Or if it's a Social Security, you would need to be the rep payee. Since I pulled up the chat while you were asking that question, I see another one just popped up. Can the disabled person have more than one person with power of attorney for them? Yes. Sometimes healthcare decisions, especially, you don't really want two people that can make the decision at the same time. And the doctors and nurses definitely don't. And actually, the state of Missouri statute says one person at a time, even if it's mom and dad. If one person says take the green pill and the other one says take the yellow pill, who does the doctor listen to? That creates a problem. With financial stuff, you can usually have co-power of attorneys, but or power of attorney agents, I should say. The power of attorney is the document, but I know we all kind of say it that way. Um, but you usually want to be able to act independently because banks don't want to make sure that both people have signed this check before they do X, Y, or Z. They're going to want it to be either or and have that on record. But you can do two co-power of attorney with independent powers. Um, is there anything else? Am I missing one, or does that get them? I think that gets them maybe. Oh wait, no.
That,
Oh yeah, that is. Yep.
that gets it.
Okay. So what kind of asset protection strategies are we not looking or recommending? Um, One of them is just giving the money away. If money used to be somebody's who is on government benefits and they just give them away, the court thought about that, and the state thought about that, and they say, well, you can't just have money and then say, now I don't have money. It's my mom's, or it's my brother's, or it's my sister's, or it's my kids. There's usually look back periods and penalties for making transfers, including disclaiming like oops, my great aunt left me an IRA and I inherited $100,000, that'll kick me off benefits. I'll just disclaim it and pretend I never got it. The A lot of the benefits are still going to count that as having it and a gift, which will probably impact your benefits. So again, best case scenario, we prevent it from ever becoming that person's countable asset. It doesn't mean don't ever give it to them. It means give it to them in a way that's not countable. But if it does come to that person and they're on benefits, we now need to figure out, do we have to do something to make it not countable, and what are our options? What are our options? One is leave them nothing. And again, I don't recommend that. A lot of times, anybody that has any special needs is the person that needs the money the most. A lot of the programs on Medicaid, you're living off $50 a month, or on SSI, less than $1,000 a month for everything they need. And it doesn't cover a lot of medical devices that could be helpful, trips, companionship, uh, legal and tax planning, whatever may come up. That's not the best thing to do. Well, some people say, oh, okay, that's fine. I have 3 kids. I'll just give 2 shares to one of my kids, 1 share to the other kid, and no shares to my kid who I might affect their benefits. And there's a lot of problems with that too. Um, Obviously they could just take it because it's their money. There's no legal obligation in that case to use it for your loved one. But even if it's somebody we really trust and care about, maybe they're getting divorced and they had money in their name, and that money is now wrapped up in a divorce, so they're about to lose half. Maybe they got sued by Discover Card because they fell behind on their own bills, and now we're losing that money to their problems. There's a lot of things that can happen. We could just spend it all. Well, again, spending it, the problem is then it's not there anymore, and we can't use it for future needs that could be really helpful. So what about an ABLE account or a special needs trust plan? I forgot I have separate slides for that, so I'll kind of hit them quickly. So disinheriting, the good side is, yeah, they'll maintain their benefits. The downside is we don't have any benefits for the person that may need it the most to supplement those programs. And then there's always what's fair. I have 3 kids. I love them all the same, but every kid is different. Every kid's needs are different. Every kid's situation is different. Um, but if we just outright leave somebody out and say, well, that's because we wanted to preserve benefits, that's probably not the best way. Giving it to somebody else, as I mentioned, divorcing spouses, creditor claims, mismanagement. Oh, I know this money is for them, but my kid really needs tuition money this year, so I'm going to use it for that, and then I'll fix it later. And later never comes, or never quite were able to stay with it. Or maybe that's that sibling or whoever you left it to predeceases, and now the money is somebody else's that didn't agree to take care of your loved one. The spend down method, again, if we're on Medicaid, you're only allowed $6,000 total. And again, generally you get $50 a month, if it depends on the Medicaid benefit you're on. And there's a lot of stuff that's not covered by that, not the least of which dental work. I mean, if you've ever had dental work, I mean, it can cost thousands of dollars. And there's nothing more important than being able to comfortably eat and talk and not have pain in your mouth. And if you had $3,000 to cover those root canals or whatever, that would be a life changer. But if you had to spend all your money down so you could keep the benefits, that's not going to be the best way. Yes, you'll keep the benefits, but there's no long-term access, and it's unavailable to supplement needs you may have in the future. So what about the ABLE Act? This isn't that new anymore. I remember when it was. It's probably been 10 years or more, but it's still pretty new to some folks. ABLE Acts were built off of the 529 statute that is used for education, but this is for people's disability expenses instead of education expenses. And some limitations are you can only have one ABLE Act account. So if mom and dad are separated and they both want to kind of contribute to things, that's a problem. If grandparents want to do things, that's kind of a problem. There's low contribution limits. You can only transfer each year the annual exclusion amount, which right now is $19,000. So $19,000, if there's $50,000 there, we can't even move it all into an ABLE account in 1 year. We got to move it over multiple years. And there's a payback provision at death, which means if there's anything left in that account at death, that'll have to go back to pay back the state to the extent they've spent any money. So ABLE Act accounts are great if the money is already owned by a person who is otherwise eligible for government benefits, and we can kind of piecemeal get it off. But I don't want to take anybody's money that is not the plan participant, the government benefits recipient, and create it in an ABLE Act account. If I can prevent it from ever becoming theirs in the first place, that's usually better. But if we do have an ABLE Act account, we can use it for any of these expenses: education, housing, transport, employment training. It's a great supplement, and it doesn't count towards that $6,000 limit or that $2,000 limit of if you're on SSI. So again, if there's earned income, if somebody's earned a personal injury award, it's a great, quick and easy way to kind of get it off the table and still be available for that person's lifetime to help supplement expenses that are definitely going to be needed. Generally, the advantages are that they can have a debit card themselves and can manage to some extent that money on their own, and it doesn't count. So that's great. There's some more control, some benefits. So again, there are a lot of times I'm creating this along with some sort of special needs trust, either first party or third party. And this is the money that I want to spend first. This is the day-to-day money. This is where their earned income goes if it's over the amount that could otherwise keep them qualified for benefits. So special needs trusts. First of all, let's talk about what a trust is. There's three parties to a trust. There's the trustor, that's the trust creator, and the source of the money that is funding that trust. There's the trustee, that's the trust manager. That's the person who could write checks or buy or sell the house or the assets that are owned by that trust. And then there's the beneficiary. That's the person who's entitled to receive benefit from that trust. So I always say, think about a trust like a chest, in the sense that by signing a trust, it doesn't mean everything that you own is owned by that trust. Only the assets that are funded to that trust are actually governed by that chest. And again, it's possible that we have multiple chests with different reasons that we're creating, or maybe different people managing it, or different sources of those funds that we want to treat the best options possible for that specific asset. An advantage of trusts are we can make sure that anything that goes into that chest is properly overseen, because you get to choose who the manager is. Who is the trustee? Is it a corporate trustee? Is it a trusted family member? Is it you? But it's not your asset. It's for the benefit of that beneficiary. And the limitation on special needs trusts, and again, we use that terminology because that's what the law says. I've heard extraordinary needs, I've heard supplemental needs, but the point of these trusts are they are available to supplement, but not supplant, impair, or diminish any forms of government or private support that they are otherwise entitled to receive. So I had a question again recently in the last couple of weeks. Someone who's creating a special need said, well, what kind of things can you use this money for? What is the discretion? And I said, well, anything that won't kick them off the benefit they're on. I'm like, well, what does that mean? Depends what benefits they're on. You know, some government benefits, you can have as high an income as you want, but you can't have more assets than X. Other benefits, you can't have any income come to you, or it's going to reduce the income that you're getting from the government, but you can spend it on certain expenses directly. So that's why, again, it comes to what is the benefit you're on. That benefit letter is going to drive. Even the exact same type of trust will work differently based on the beneficiary's benefits that they're receiving. Because our goal is to protect the assets from the lawsuits, creditors, divorces of the person that funded it, of the beneficiary. We want to maintain any government benefits. Obviously protect against abuse. But this money is there to make life better, to pay for the things that the state says, we're not going to pay for you to take that vacation. We're not going to pay for you to have that dinner out at the restaurant. But these trusts can. And we can have people you choose in control instead of having a court in control, instead of having all the expenses of lawyers and courts involved, you can have someone you trust. The benefits are, depending on the type of special needs trust, we might be able to avoid a Medicaid payback. So if you fund a third party special needs trust, in other words, money that's not the beneficiary of the government benefits, and that money goes to fund this trust, it could help supplement that beneficiary's life. But when they pass away, you could say, and then I want the money to go to this other sibling or these nieces or nephews or this charity. And we don't have to have it go to the government to the extent they've paid any money. Again, continued management after you're not there to manage it anymore. Lifetime use, huge benefit. So the different types of trust that you're going to hear about: first party, third party, pooled special needs. First party special needs trust is the beneficiary themselves has money. Usually it's because of an inheritance from somebody who didn't plan and they just left them as an outright beneficiary on some account or some IRA or the house or whatever it may be. Or they were the recipient of a personal injury award or something from the court that says this money is yours. It's not mom's, it's yours. And it's got strict guidelines of how it can be used. It's got to be irrevocable. And one of the biggest downsides is any money left in a first party trust does have to have that payback provision, or else it's a countable asset and they're going to lose their benefits. So it's better to have it in that first party trust, continue to get the benefits, but hopefully we're using that money during the lifetime of the beneficiary, because anything left isn't going to somebody else you chose. It's going probably back to the government to pay them back. Third-party trusts are funded by assets that beneficiary does not own. So one thing you can do ahead of time is make sure anything that you're leaving that's your money for the benefit of someone who might be on government benefits now or in the future is do not ever let it become a countable asset for them. Does that mean don't ever leave it to them, leave it to their siblings? No, it almost assuredly means create a third-party special needs or supplemental needs trust within your own plan. And a lot of times we're writing that into our clients' revocable living trusts, 1/3 to healthy son, 1/3 to healthy daughter, and then 1/3 to a beneficiary who's on some sort of government means tested benefits or maybe in the future as a special needs trust. Now that money could fully fund that trust. It could be $1 million. And it doesn't kick them off any benefits, because if you think of that like a little tube of toothpaste, it only becomes theirs when the trustee squeezes the toothpaste out onto their tube or onto their brush. Everything in the tube is not theirs yet. So if they pass away, we can have that toothpaste go to somebody else when they've passed away. We can have broad discretion about who gets it, how and when. We can have broad discretion about the things that are paid. We could even have 2 or 3 beneficiaries of the same third-party special needs trust that doesn't kick any of them off the government benefits, and the trustee can decide how and when to use it for which one, which is not the case for any ABLE account or first-party trust. And again, you may be able to even revoke that if it's you that's creating that while you're alive. Now, pooled trusts, you can have either first-party or third-party. Generally, you're going to have a nonprofit organization investing it, and as the trustee, we really use this as a backup plan as opposed to the standalone first party or third party trusts. When the beneficiary doesn't qualify for one of those, sometimes there are age restrictions that prevent that, or there's not an appropriate family member to serve in that role, but it is a good option in that case too. How do you choose the trustee? You want somebody who's going to be an advocate for the beneficiary. You want somebody who's going to be accountable to the beneficiary and any other people that might be caring about that beneficiary. And you want somebody with some sort of financial, legal understanding or knowledge or wherewithal, or at least the good sense to find the help when they don't know what's going on. Generally, the trustee should not send assets directly to the beneficiary, because It could count as income, and it definitely counts as a countable asset. And again, depending on the benefits they're on, that's a problem. They should not commingle the trust assets with other assets and blur the line of how that asset is to be handled. And if they're on SSI, you definitely don't want to be paying for food, shelter, clothing, because that would reduce the benefit of the monthly income that they're getting. So generally, the trustee is going to pay for these things directly. So pay the school directly, pay for the expenses that aren't covered by their monthly income, vacation, travel, vehicles, cell phone, internet, care that's not covered by benefits. Those are all things we routinely see. Everybody's needs are different. So again, I always start with plan design. Number one thing, talk about your situation specifically. Everyone's situation is different. How long do we want that money to last? Because that'll change how much discretion, how we want it to be invested. And then create a plan to make sure if you're not there to be the advocate, we've got a then who, and then who, and then who for the whole lifetime of the beneficiary. So here's some areas to consider. Can your loved one manage finances without great assistance, or with assistance but could still do some things on their own? Would the inheritance disqualify them from the benefits that they're currently on, or benefits that they might be on in the future? Because once we squeeze it out, we can't unsqueeze it out. So it might kick them off something we didn't even contemplate in the future. And will there be enough there to provide for their lifelong needs? And are they at risk to be unduly influenced? Because if so, we definitely want to protect the money. Your own disability, your own personal injury, the beneficiary's future greater disability than they have at this point, or personal injury, inheritance, again, when they didn't know that they were going to be inheriting. All of these things are things that we want to think about. Taxes. How the income is being taxed when you're using any kind of trust-based planning, or when you're creating assets that somebody's in charge of for the benefit of somebody else. There's a lot of tax considerations. Is it a completed gift? Is it not? Does it have its own tax ID number? Does it not? Should it file a separate tax return? Should it not? Is it being taxed at the trust level, which gets higher faster than an individual? And is there a way we could spray that out to somebody else? What are the needs? And again, coordinate that with your own estate plan, which everybody should have an estate plan. There's a lot of common misconceptions. One is that any estate planning is only for people with millions and millions of dollars. No. Estate planning means if you didn't wake up tomorrow, what the heck would the people that depend on you do? What income continues or doesn't? Where are the assets that you have that you've been relying on? What are the account numbers? Where are they? Because guess what? Fidelity has Fidelity paperwork. Schwab has Schwab paperwork. Vanguard has Vanguard paperwork. They all have their legal departments. Commerce Bank, Bank of America. You got to coordinate your life. And if you weren't there that day, would your spouse be able to step in? Would your child be able to step in? Would your brother be able to step in? Would your sister be able to step in? Most people think not everybody does this. I don't understand, we have thousands of clients in the St. Louis area. I promise you people are doing this. I promise you it is valuable. It is not to break you. Saving your last $100,000 or $200,000 is vastly more important than saving the first million of somebody who has $16 million. But for some reason, the people that spent their whole life saving up to pay off their house and to have $100,000 in a CD or a couple $100,000 in an IRA think they don't have enough money to protect it. Just assuming that people are going to take care of it, or that your beneficiary will be able to live when it could cost $14,000, $15,000, $16,000 a month for the care, is not appropriate. And it's never too soon, because whatever you do today will still be there tomorrow and 5 years from now. But if you don't do it today, I don't know whether you'll be there today, tomorrow, or 5 years from now, or 20 years from now when you decide to actually do it. Everybody needs a plan. Again, no matter what your wealth is, no matter what your age is, you should have some sort of plan, especially if you're 18 or older. But if you are a disabled recipient of benefits, or you're the parent or loved one that wants to care for someone who's receiving benefits, or you're a spouse of somebody, and you may not be disabled and they may be receiving benefits, you should have a plan. Why doesn't everybody do it? We're overwhelmed. We lack knowledge. We're in denial. The impact of those things would be lost benefits that you should be getting, added expenses that you shouldn't have to be paying, the wrong people in control because you didn't take the time to choose the right people, the caregivers burning out because they thought they could handle it and then they can't. We don't have a backup plan. Your own stress, tension, and confusion that you could hopefully avoid with having a plan. And that non-action does have an impact on your loved one. So again, I really encourage you to hire professionals to make sure it's done correctly. You know, most people, and us, I'll tell you specifically, will meet with you for no charge and find out what's going on. And if there's a way that you can help yourself or help your loved one or your family that you haven't done, we can usually say at the end of that first meeting, here's what you should do. Here's what it'll cost. Here's why it makes sense from our perspective. And then you can say, sounds good, let's do that, or no thanks, and that's okay. But you should always be including professionals, whether it's attorneys, case managers, advocates, accountants, financial advisors, insurance agents. Here's our roadmap. I'm a visual person. So again, I told you I'd end with, if you wanted to do anything with our firm, how we handle it. I always encourage people to be educated first. We have an online webinar for just planning in general, wills, trusts, powers of attorney that we send people before their appointment. But we would always say free 60 to 90-minute meeting with my partner, Jackie Capriano, to figure out what the plan is, what it would cost, what do we do next. Within the next couple of weeks, we'd say, now let's get all the statements, the car titles, the house titles. Where is all your stuff if you didn't wake up? Let's create an inventory and let's figure out how we're going to fund that plan. And then you'll get together with me and I'll do what we call a risk assessment, asset alignment. We do look at tax effects. We look at government benefits effects. Why do we treat this bank account different than that bank account? Or why might I treat the IRA differently than your life insurance? And we'll go through all of that and over the course of about an hour. And then we'll sign everything. And then again, the way our firm works is we have lifetime communications updates. I wish I could tell you that you do estate planning once, you put that on the shelf and you say, thank God I did that, for the next 20 years, you're good. All this stuff changes, your life changes, health changes, life changes. It's something I want to see you at least once a year to go over, but as you need it. One thing we have because of our relationship with the Gateway Down Syndrome Association is we give 25% off anything that you would be doing. If you Googled best estate planning lawyers in St. Louis and Eamon, Gantner, and Capriano came up and you loved all the reviews you were reading and you set an appointment, you would pay this. If you say, I came because I'm associated with Gateway Down Syndrome Association, you pay 25% less of whatever that is. And again, we would offer a free consultation just because you're here. So feel free to plan that. And again, our goal at that meeting, that first meeting, is figure out if we can help you, what your situation is. We give a brief 2 to 3 page intake form and we say, let's fill out that before you come in so we don't spend the whole time saying, and what's your name and what's your son's name, and kind of go from there. But if you bring that in, by the end of that 60 to 90 minutes, we'll have a plan and what you can do to put all this knowledge into action and be part of our law firm family. And again, I only say our stuff. Again, I don't intend this in any way to be some sort of like sales pitch or anything else. But it is important to us as a law firm, our partnership that we've had and our sponsorship of different Gateway Down Syndrome Association events. And I want to be a resource, and I can only tell you how we do it. I can't speak for anybody else. But share what you learn with others, family, friends, business associates, neighbors, church friends. Like I said, we do a lot of speaking in the community. This will be recorded. I'm sure if people in the group have not attended today and you think it would be helpful, hopefully, again, even though I understand it's drinking from a fire hose, it's somewhat helpful. I tried to stay as best on time. I'm sorry it's 7:32, but I see a couple of chat spots there.
You did
Um,
fine. Thank
okay,
you.
good.
Thank you so much, Paul. We definitely appreciate it. Take a minute and drink a little water. And there are two questions that are in the chat.
Okay.
Um, let's see. Woohoo! Uh, Question from Christine is that do you still have a social worker in your office to help with benefits?
We do. We have three social workers in our office, actually. And I can tell you again, when I go through this stuff for clients, for my own family, when I've done this, um, there are things I don't understand about discharge planning from a hospital or skilled nursing, or how do we move, how does Medicare cover this and not that? And our social workers are a wealth of knowledge. Um, so in our website is yourestateMatters.com. You can look it up and who our team is. I think we have different staff profiles. Um, Gail Lee has been doing this for decades and just the best at reading that stuff. Maggie Burgess, Krista Massey works mostly on the estate administration side, but she also is a social worker. And uh, all clients of our firm, again, we don't like to do hourly billing or, oh, I'm going to nickel dime you on this thing because, it wasn't part of this. We always say, you get us when you become a client and just define the scope of that relationship.
All righty. Another one, if we already have trust in place, are you available to review what we already have?
Yep. Great question. I would encourage you to schedule that meeting with our office and that plan design personal consultation. Bring whatever documents that you have with you because inevitably you're going to say, I have a trust, can I do X? Or I have a power of attorney, can I do Y? Or does this mean X or Y? Guess what we get to say as attorneys? It depends. It depends what that trust says because a trust is not a trust is not a trust. A will is not a will is not a will. So it might be that you thought you had this thing set up for this purpose, but the way it's written doesn't. Or maybe you've got everything that you need, um, but you want to change an agent or something, or maybe it's perfectly fine the way it is, and now you have more knowledge, and you can add additional resources to that, and that's all perfect. And it's free either way. Again, we call it a personal consultation plan design, or sometimes like a plan audit, plan review. Um, so yeah, all of that.
One question that I got from a family, Trust and Wills. That's something. That's an online site for wills. What would you say about that, Paul?
Yeah, that's a great question. Again, a lot of us think about wills and trusts as a document that we have to sign, and that estate planning is signing a will or trust, and that all wills are the same and that all trusts are the same. And if that were the case, you would need to know nothing other than what does it cost, right? Because that's what we first think about is, and it's 2026, Chat GPT, how can I get the cheapest will in St. Louis? Or but what you don't know is that estate planning uses some of those things as tools, and some are certainly better than others. But those documents are not a plan. Those documents are tools to carry out a plan. And if that plan wasn't well thought out, if that plan wasn't asking the right questions, if that plan didn't understand benefits that were available that you didn't know that were available to you, it's not going to add a lot of value. So to me, it doesn't make any sense to do those things. I mean, again, I've seen through the years LegalZoom turn into Susie Orman's QVC turns into, I mean, all of those things are commodities telling you that these documents are something that they're all the same and they're not. So, generally speaking, you get what you pay for. I personally am somebody that wants the best at the best value. And I also want to say, here's what I know and here's what I'm good at. And I'm going to pay this person to do that because I don't even know the right questions to ask. And that's why I have them. I don't need to know. So I hope that answers that question in a safe way.
It it did. It
Yeah,
it
okay.
very much did. Thank you. Thank you. thank you. Are there any other questions? You can come off of your mic and open up your mic and speak if you like. Uh, uh, can you please give a ballpark figure of how much estate planning cost?
Yeah. And in our webinar that we go through everything, we definitely go over, like on the intake form, we go over different cost, prices, and plans. But since you've kind of heard some of this, most of our clients do what we call as a legacy plan, which is your trust, your will, your powers of attorney, whether it's updating from somewhere else or our thing to become a client, get all those documents, but more importantly, have us and all of our resources, including writing in any third-party special needs trusts or whatever you got for your assets, is typically $5,400. And again, and that's before the 25% discount, which you get, and our consultation is free. We do have more entry-level plans where it's more non-probate avoidance, wills, powers of attorney, et cetera, where it's less, I want to say maybe 3,500 or somewhere around there. And then we have like super advanced um, asset protection type plans to avoid nursing home expenses or avoid estate taxes and things that could cost in that higher range. But I hope that's kind of like a ballpark figure that makes sense. Gives us at least something.
Thank you.
The next one is, what role would a family navigator have in all of this? How could they help? So are you familiar with family
I'm not sure I do.
navigators?
I am familiar. Can you help me with that?
So St. Louis Arc, the St. Louis Arc, Sunny Hill, Easter Seals, UCP Heartland, they have people that are there that basically you get in touch with a family navigator and they help you navigate through different things. For example, if you are a family member and you want to apply for SSI and you've gotten, it's just too much, they can help you literally navigate all through this. They have a lot of resources and they're very, very knowledgeable.
Yep. Um, yeah, so our firm has a relationship with most, if not all of those groups
All
that you said. And again, the key, and I do education for them as well. And so what I've done, I hadn't heard that term, I guess, specifically, but usually our social workers are in touch with that person too.
Mm-hmm.
And the family, again, as much as the family can say, you guys do it, and then just let the benefits start happening, we keep them in the loop, but as much of the work as we can take off the table, we do. And again, we are not on an hourly clock. If we're talking to a navigator, a family advocate, or something that you've authorized on your behalf, that's included in being a relationship. And again, we don't step on anybody's toes. We are not doctors. We are, again, our social workers are there to help be an advocate for you. But anybody who has more information about the health and needs, our goal is to figure out how to pay for it in the most cost-effective, tax-effective way, find out any benefits that are available, and help you get them.